powered by SIG production in Philippines. Dalawang Batas sa Pilipinas. Dapat, mong Malaman. Republic Act No. 7438. April 27, 1992. Republic Act No. 7438, April 27, 1992. An act defining certain rights of person arrested, detained or under custodial investigation as well as the duties of the arresting, detaining and investigating officers, and providing penalties for violations thereof, be it enacted by the Senate and House of Representatives of the Philippines and Congress assembled. Section 1. Statement of Policy. It is the policy of the Senate to value the dignity of every human being and guarantee full respect for human rights. Section 2. Rights of persons arrested, detained or under custodial investigation. Duties of public officers. Any person arrested, detained, or under custodial investigation shall at all times be assisted by counsel. Any public officer or employee, or anyone acting under his order or his place, who arrests, detains or investigates any person for the commission of an offense, shall inform the latter, in a language known to and understood by him, of his rights to remain silent and to have competent and independent counsel, preferably of his own choice, who shall at all times be allowed to confer privately with the person arrested, detained or under custodial investigation. If such person cannot afford the services of his own counsel, he must be provided with a competent and independent counsel by the investigating officer. LAWPHI 1. The custodial investigation report shall be reduced to writing by the investigating officer, provided that before such report is signed or thumb-marked, if the person arrested or detained does not know how to read and write, it shall be read and adequately explained to him by his counsel or by the assisting counsel provided by the investigating officer in the language or dialect known to such arrested or detained person. Otherwise, such investigation report shall be null and void and of no effect whatsoever. Any extrajudicial confession made by a person arrested, detained or under custodial investigation shall be in writing and signed by such person in the presence of his counsel or in the latter's absence, upon a valid waiver, and in the presence of any of the parents, elder brothers and sisters, his spouse, the municipal mayor, the municipal judge, district school supervisor, or priest or minister of the gospel as chosen by him. Otherwise, such extrajudicial confession shall be inadmissible as evidence in any proceeding. Any waiver by a person arrested or detained under the provisions of Article 125 of the Revised Penal Code, or under custodial investigation, shall be in writing and signed by such person in the presence of his counsel. Otherwise, the waiver shall be null and void and of no effect. Any person arrested or detained or under custodial investigation shall be allowed visits by or conferences with any member of his immediate family or any medical doctor or priest or religious minister chosen by him or by any member of his immediate family or by his counsel or by any national non-governmental organization duly accredited by the Commission on Human Rights or by any international non-governmental organization duly accredited by the Office of the President. The person's immediate family shall include his or her spouse, fiancé, parent or child, brother or sister, grandparent or grandchild, uncle or aunt, nephew or niece, and guardian or ward. As used in this act, custodial investigation shall include the practice of issuing an invitation to a person who is investigated in connection with an offense he is suspected to have committed, without prejudice to the liability of the inviting officer for any violation of law. Section 3. Assisting counsel. Assisting counsel is any lawyer, except those directly affected by the case, those charged with conducting preliminary investigation, or those charged with the prosecution of crimes. The assisting counsel other than the government lawyer shall be entitled to the following fees: the amount of 150 pieces if the suspected person is chargeable with light felonies, the amount of 250 pieces if the suspected person is chargeable with less grave or grave felonies, the amount of 350 pieces if the suspected person is chargeable with a capital offense. The fee for the assisting counsel shall be paid by the city or municipality where the custodial investigation is conducted, provided that if the municipality or city cannot pay such fee, the province comprising such municipality or city shall pay the fee, provided that the municipal or city treasurer must certify that no funds are available to pay the fees of assisting counsel before the province pays said fees. In the absence of any lawyer, no custodial investigation shall be conducted, and the suspected person can only be detained by the investigating officer in accordance with the provisions of Article 125 of the Revised Penal Code. Section 4. Penalty Clause. Any arresting public officer or employee, or any investigating officer, who fails to inform any person arrested, detained or under custodial investigation of his right to remain silent and to have competent and independent counsel preferably of his own choice, shall suffer a fine of 6,000 pieces or a penalty of imprisonment of not less than 8 years, but not more than 10 years, or both. The penalty of perpetual absolute disqualification shall also be imposed upon the investigating officer who has been previously convicted of a similar offense. The same penalties shall be imposed upon a public officer or employee, or anyone acting upon orders of such investigating officer, or in his place, who fails to provide a competent and independent counsel to a person arrested, detained or under custodial investigation for the commission of an offense, if the latter cannot afford the services of his own counsel. Any person who obstructs, prevents or prohibits any lawyer, any member of the immediate family of a person arrested, detained or under custodial investigation, or any medical doctor or priest or religious minister chosen by him, or by any member of his immediate family, or by his counsel, from visiting and conferring privately with him, or from examining and treating him, or from ministering to his spiritual needs, at any hour of the day, or, in urgent cases, of the night, shall suffer the penalty of imprisonment of not less than 4 years nor more than 6 years, and a fine of 4,000 pieces. Law 1. The provisions of the above section notwithstanding, any security officer with custodial responsibility over any detainee or prisoner may undertake such reasonable measures as may be necessary to secure his safety and prevent his escape. Section 5. Repealing Clause. Republic Act No. Number 857, as amended, is hereby repealed. Other laws, presidential decrees, executive orders or rules and regulations, or parts thereof inconsistent with the provisions of this act, are repealed or modified accordingly. Section 6. Effectivity. This act shall take effect 15 days following its publication in the Official Gazette or in any daily newspapers of general circulation in the Philippines. Approved. April 27, 1992. Number 2. Miranda's Right. Anyone who has seen an episode of Law and Order, NCIS, or any other police drama, has heard a police officer recite, "You have the right to remain silent." If you give up the right to remain silent, anything you say can and will be used against you in a court of law. You have the right to an attorney. If you desire an attorney and cannot afford one, an attorney will be obtained for you before police questioning. These statements, or similar advisories, are generally known as Miranda rights. But what exactly are Miranda rights, and what are they designed to protect? Who is Ernesto Miranda? Miranda rights are named after the landmark U.S. Supreme Court case Miranda v. Arizona. Ernesto Miranda was arrested for stealing $8 from an Arizona bank worker. After 2 hours of questioning, Miranda confessed not only to the robbery, but also to kidnapping and rape. When he was brought in for questioning, he was never told that did not have to speak to police or that he could consult with a lawyer. He simply confessed to the crimes. He was found guilty. Miranda's conviction was appealed to the United States Supreme Court. The justices ruled that the statements Miranda made to the police could not be used as evidence against him because he had not been advised of his constitutional rights. Since this decision, police are required to recite the Miranda warning to suspects before any questioning is conducted. The Miranda case did not establish new rights, but rather instituted further protection of Fifth and Sixth Amendment rights. The following is the standard Miranda warning: you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to speak to an attorney and to have an attorney present during any questioning. If you cannot afford a lawyer, one will be provided for you at government expense. Each state makes its own rules about exactly what must be told to suspects who have been arrested or are being held for interrogation by police, but the Supreme Court ruling requires these 4 points to be clearly communicated. 1. You have the right to remain silent. Silence cannot be used against defendants in court. However, there is a term known as pre-Miranda silence, which occurs when a suspect has not been read his or her Miranda rights and still remains silent. In that case, silence can be seen as unusual and suspect. Suspects who state something like "my attorney has always told me not to give statements without him present" may avoid the negative consequences of refusing to speak. 2. Anything you say can be used against you in a court of law. All suspects have the right to remain silent. Those who give up that right face the prospect that their statements will be used against them in court. This can be tricky, as many times the only evidence against a defendant is a confession. Defense lawyers contend that many innocent suspects, intimidated by arrest and interrogation, may speak to police without realizing the danger. 3. You have the right to have an attorney present. This gives a suspect the right to have legal counsel present at the time of the interrogation. A suspect must be clearly informed that he or she has the right to consult with an attorney and have an attorney present before answering any questions by police. If the police try to question a suspect after an arrest, they must stop the interrogation if the suspect requests an attorney. 4. If you cannot afford an attorney, one will be appointed to you. In order to make sure a person being interrogated has a clear understanding of his or her rights, the suspect must be told that a lawyer will be appointed without charge if needed. Without this additional advisory, the caution of the right to consult with an attorney could be misunderstood and rendered meaningless. Arrest without the reading of Miranda rights. The Miranda decision is intended to make suspects aware of their constitutional rights. Police can ask routine questions such as name, address, date of birth, and social security number without reading Miranda rights. Again, most states enforce their own rules on when and how police officers can place suspects under arrest, so it is difficult to generalize. What happened to Ernesto Miranda? Ernesto Miranda did, indeed, get a new trial based on the Supreme Court ruling, and his original confession was thrown out. However, based on the evidence, Miranda was again convicted of kidnapping and rape and served 11 years in prison before being paroled in 1972. In 1976, at the age of 34, Miranda was stabbed to death in a barroom brawl. Police arrested a suspect in the killing who, after choosing to exercise his Miranda right to remain silent, was released without being charged for the crime. Thank you for watching. Please click the subscribe button